Mental Capacity Act applies to anyone aged 16 or over, so 16 and 17-year-olds must be presumed to have decision-making capacity unless proven otherwise. As families and carers, we often know the person being assessed best, and have usually known them for a lot more years. We can be a rich source of information about how best to engage with someone, and may understand the person's way of communication better.
For some people, language or cultural differences or a person's learning disability may mean that it takes more time and effort to help and support patients and their families in discussions about capacity and decision making, so making sure that they are making informed decisions. Therefore, health and care services must make reasonable adjustments for people with a learning disability, and if there are language barriers, an interpreter must be used. It might also be useful to have resources and documents in an accessible format, so ways that that person can understand to help them make those decisions.
When a decision is being considered for a person who lacks mental capacity, our views must be considered. The law sets out clear rules about exactly what families and carers are allowed to do, and importantly, what we're not allowed to do. We cannot consent or otherwise agree or refuse treatment or care on behalf of another person.
As family and carers, we need to remember that the person we care for has the right to make a decision that we might consider unwise and actually not be the right decision. A person shouldn't be treated as not having capacity, so not being able to make a decision just because they make a decision that we think is unwise and that we don't agree with. We're involved so that we can support services to get the person's view themselves.
Families and carers must always be included in a best interest decision meeting unless there's a specific reason not to include us, for example, a safeguarding concern. The views of us as family or carers is one of several that will be considered in that meeting. Health and social care professionals have a duty to keep us engaged and informed about what the best interest meeting decides.
There are, however, two ways that you as a family member or a carer can be given the authority to make legal decisions on behalf of your loved one. The first one is the lasting power of attorney. A lasting power of attorney is a process where a person can appoint one or more deputies to make decisions on their behalf, only though while they have the capacity to do so. This will be for a time when they become unable to make decisions for themselves. A second legal way is through a welfare deputy. A welfare deputy is appointed by the Court of Protection, granting a specific individual the right to make decisions about care and treatment on behalf of a person who lacks the capacity to do so themselves.